So, Jeff, I want to get started by asking you about the role the Attorney General's office played in the Kohberger investigation, but also maybe other investigations, because a lot of people might not understand where you guys come into play.
Absolutely. Yeah, so the way it's set up in Idaho, our system is that the local county prosecuting attorney is responsible for prosecuting all crime within their county. The attorney general has limited jurisdiction over specific subject matter areas. For example, we have our Internet Crimes Against Children unit, and so we can both investigate and prosecute those crimes. But the vast majority of crimes, murder, for example, is handled by the local county prosecuting attorney. And our office gets involved only upon request of the prosecuting attorney. And that can either be a request to take over the case or, like it was in this case with Kohberger, to just step in and assist and provide some supplemental resources so the county can continue handling the case.
I see. So, Latah County reaches out to your office and says, "We need some help," and that was that mainly with the actual preparation for trial.
So it actually wasn't so much focused on the trial as it was on the legal briefing and argument before the court. And really, in this case, the way it played out, the current Attorney General, Raul Labrador, came into office in January of 2023. And when he first came into office, he gave me a list of 3 or 4 topics that he wanted to be briefed on related to criminal law. And one of them was this case. And when we met, his question was, what can we do to help? Is there anything our office can do to help? And so I explained that at the time, our office under the previous attorney general would not agree to step in and assist county prosecutors. We would only take the case over. So it was a take it or leave it approach. And I explained to the attorney general that I thought we could do more than that, and that I thought we could and should offer to assist in the right circumstances. And so shortly after that, it's my understanding that the Attorney General reached out to Bill Thompson and said, "We're here for you. We support you. Whatever help you need, whatever you want that to look like, we're happy to help you." And then it was in March or April that Bill Thompson called me and requested that help.
I
And it
see.
started it started with a request to help with the grand jury. And then once we got through that, our role really kind of organically became we did most of or a lot of the brief writing and legal argument in front of the court.
Okay. So that can help paint the picture as to your involvement in the hearings and the written documents leading up through those hearings. What were the type of things that your office was assigned? Like, were there particular areas that you're like, all right, we have this, and Laytalk can do this, or was it kind of just as things would come in, filings from the defense that you would work on? How did it work?
So it was all under the leadership of Bill Thompson. He was the one that was assigning out who would do what. But again, kind of organically, the way that it played out, our office took over anything that was really focused more on the law and less maybe on the specific facts of the case, because we weren't there for the investigation like Bill was. And so some of the topics that we handled were after there was an indictment, they moved to dismiss that indictment, and we handled the briefing and argument on that. We handled the change of venue. We handled my personal role, my biggest role probably in the case, was handling all of the briefing and argument related to investigative genetic genealogy. That was a new issue in Idaho, and so it was a pretty big deal. And so Bill asked me to kind of step in and take that on. And then we handled the slew of motions that were filed to try and strike the death penalty as well.
Wow, those are some pretty big areas there. I want to ask you about the genetic genealogy stuff. Tell me how critical that information was to this case.
So the way I would say it is, it was essential to the case. I think something you need to understand about the investigative genetic genealogy is this was an issue of first impression in Idaho. So no court had addressed a constitutional challenge to the use of investigative genetic genealogy. And when the defense moved for that in this case, everyone understood that what they were seeking was to try and keep the DNA out of the trial. But I don't know that everyone fully understood that the way the Fourth Amendment works, if the state were to lose that argument, you don't just lose the evidence itself, you lose anything that came from that evidence. You may have heard the phrase fruit of the poisonous tree. And in this case, because the investigative genetic genealogy is how they identified the defendant, that would have meant virtually everything. The stakes couldn't have been higher with respect to the evidence pointing to the defendant. If you watch, when I did the oral argument in that, Judge Hippler, his very last question to me was, Mr. Nye, if the FBI did in fact violate Mr. Kohberger's constitutional rights, you would agree that that would burden the state, is the way he phrased it. And what I understood him to be asking, and what I believe he was asking was, you agree with me that if I find that this was a violation of the Constitution, you lose everything, pointing to the defendant. And I said yes. So that the stakes were pretty high on that one.
That huge.
Yes.
So just to summarize, in case people missed that part of the build up to the trial, is the defense was saying that the DNA, and correct me if I'm wrong, Jeff, was obtained illegally or unconstitutionally. Therefore, it should not be admitted as evidence. The prosecution, your team, was saying it should be admitted as evidence that it was constitutional in the way that they obtained it, and the judge did end up letting it in. Is that right?
Correct. Yeah, and when you say the way they obtained it, we're talking they had several different arguments along the path, but yes, they were arguing about the way they found him was the DNA that was on the knife sheath. There was single source male DNA. They didn't have anyone they could connect to that DNA, so they didn't have anyone to test to compare it to. Traditionally, when you're doing DNA testing in the criminal world, you have an individual, you have the DNA from the item, and you can compare those two things. Here they had DNA, but they didn't have the individual. So how do you find them? Well, that's where investigative genetic genealogy comes in. And they literally they reverse engineer a genetic family tree to figure out who could this person be. And then they get a warrant to arrest that person. Now they have the person and they can compare it to the DNA. And so, because that's the way they used to find the defendant in this case, all of the evidence was fruit of those actions. And so, again, if we had lost that motion, it would have been devastating to the case.
Well, and not only this case, but in future cases, right? Couldn't future cases point to this one as precedent and say it wasn't allowed in then, it shouldn't be allowed in now?
Absolutely. From a legal perspective as well, it was a really big deal to set the legal landscape on, is investigative genetic genealogy going to be allowed in Idaho's court system? There
So
are
we're,
other.
oh, go ahead.
Oh, I was just going to say there are other courts in other states that have addressed it. Not very many at this point, but it has been addressed. But this was the first time that it was addressed in an Idaho court. Is Judge Hippler's well written decision?
Yeah. Were you nervous going in for that argument and preparing the brief?
Yeah, I was. I'm always a little bit nervous when I argue. I think on this one, I was very confident in our legal position. We stand by the technique. We stand by law enforcement using that technique. It is constitutional, but when the stakes are as high as they are, then yeah, I'm always a little bit nervous about it.
You mentioned the change of venue being one of the other issues your office dealt with. Why was that so important to move the trial so far from where the crimes happened?
Yeah, the change of venue was an interesting issue in this case. I think everybody watching kind of had an intuitive sense of why you may want to move it. This crime affected, these horrific crimes affected the community directly there. There were students at the University of Idaho, which is a big part of the community there. And so the defense's argument was, in order to get a fair jury, we need to move this. And the state's position wasn't full disagreement with that. The state's position was, we should try to seat a jury and see if we can get one. And if not, then we can change venue. But ultimately, the judge decided, let's just go ahead and change it to be safe. And that's why it was moved to Ada County.
Over all the months and months you spent working on this, what would you say is the biggest surprise that you found?
The biggest surprise, I would say, uh, would be the guilty plea at the end. I think that was a surprise for me. Now, you have to understand the role that we were playing in the case again. Latah County was making all of the decisions, and they were the ones who were engaging with the defense team. I wasn't involved in those conversations, but I was consulted, I guess you would say, on my thoughts and opinions and other things. And so I wasn't shocked in the sense that at the change of plea hearing, I knew what was going to be happening. But leading up to that, uh, every indication I had seen and believed was that the defendant had no interest in pleading guilty and wanted a trial and believed that he could be vindicated at that trial. That was just kind of my assumptions and reading the tea leaves, if you will. And so that I would say that was probably the biggest surprise that that's how it ended.
Yeah, I think it was a surprise for many people. Do you think it was because all of these motions against the defense came down against them leading up to trial? Do you think that that maybe put pressure on, Bryan Kohberger to take a plea agreement?
I, I do think that that is at least part of the calculation. I can't in any way speak to his motivations or why he decided at the end. Obviously, I've never spoken to him about it. I don't know why his attorneys, what they advised, if anything. So anything it's kind of just speculation on my part. But absolutely, I think one of the reasons that they bring challenges to things like the death penalty is to try and chip away at as much as they can from the state side and any leverage that the state would have. And so, yeah, I mean, that the way you resolved this was by giving up the death penalty in exchange for guilty pleas to everything in the indictment and maximum penalties on every charge. And so at the end of the day, protecting the death penalty meant something to that resolution.
I want to ask you, and I don't know if you're the one that would be able to speak to this, or it might be somebody else. But from what we understand, the plea agreement was no appeals. He can't appeal. But Judge Hippler mentioned that he had I think 42 days or something if he wanted to appeal, but then said that if he did, it might void the plea agreement. Can you explain that? Because I know a lot of our viewers were confused when the judge said, "Oh, you do have a certain amount of time to appeal."
Yeah, absolutely. So I'm more than happy to handle this. And I just for a little bit of background, I guess, for the viewers, in our division, in the criminal law division, I also supervise the appellate unit, and they handle all criminal appeals in the state of Idaho. And so, if there were to be an appeal, it would come to our office, and we would be the ones handling it. So that's kind of the background I'm coming from on this. So, Judge Hippler was getting at a couple of different things. Let me start with the appeal waiver itself. It's not uncommon when a defendant pleads guilty to waive their appellate rights, and that's typically how it's phrased in the plea agreement. But what we know, and there's actually a case on this that came out of Idaho and was decided by the U.S. Supreme Court called Garza v. Idaho, uh, is that a criminal defendant cannot actually waive all of their appellate rights. There is a narrow category of issues that you cannot waive. And really, what that's focused on is the validity of the waiver itself. So, while in this case, the defendant waived his appellate rights, that means he waived his right to challenge things like the change of venue, the IGG, motion to suppress, the challenge that he raised to the indictment. He doesn't get to challenge any of those. But what he can't waive is an attack on the validity of the plea agreement itself. And
Mm.
so he could raise a challenge. For example, he could claim that his attorney provided him ineffective assistance in advising him on the plea agreement. And if he were to win that, it would have to be that the court finds that he didn't enter that plea knowingly, intelligently, and voluntarily. And
Mm.
so, no matter what language you put in the plea agreement, you just cannot waive that. So, that's part of what Judge Hippler was referring to. Then there's the second part you mentioned where Judge Hippler did make a comment about by filing a notice of appeal, you may actually violate your plea agreement. That one I personally would consider a little bit more of an open issue as to whether or not that's something that the state could argue that just by filing the notice of appeal, we could argue, well, now he's violated the plea agreement, so we want to go back, we want our trial, and we want to impose the death penalty. I guess we would just have to see how that one plays out if it came up.
I see. But if for some reason he does decide to appeal, as with all other cases, it does end up in your office.
Absolutely, it would. Yes, and another part to understand about waivers of any kind or appellate waivers, the court clerk at the Idaho Supreme Court is not going to refuse to accept an appeal from him just because he's waived it.
Yeah.
You can really, as I've learned in my job, you can really file just about anything that you want to. The question is just, are you going to get anywhere with it? So let's say that the defendant here, Mr. Kohberger, decides to appeal and challenge the IGG ruling. Well, the response, he would be allowed to file that. The court's not going to stop him. But the response from our office would be to file a motion to dismiss that appeal, and we would cite to the plea agreement and say, he's waived this. And I'm confident that in that situation, the court would just dismiss the appeal.
I see. So it's going to be if should that happen, it's going to be much quicker than some of these other cases, like the Daybell cases or whatever, that take years to work their way through the courts.
Absolutely. And even in that narrow category that I talked about of if he tried to challenge the validity of the plea agreement itself, even in that area, it's a very narrow area. And so it's not going to last for years and years. And if you watched the change of plea hearing, you saw how careful Judge Hippler was in asking all of those questions that I think for a lot of lay people sound very repetitive. And you almost start rolling your eyes like, is he seriously asking that question again? But it's because he needs to be thorough so that the record is accurate that no, he was in fact entering this plea of his own free will. There was no improper influences on him. And so if Mr. Kohberger were to raise that challenge now, we have that change of plea hearing transcript we can rely on to say he knew exactly what he was doing.
Yeah. Okay, I appreciate that explanation. There were so many people that were quite pleased or happy that this was a plea agreement, that the trial didn't happen, that he goes away, we don't hear about him. Uh, there were a few others that weren't, including one of the family members of the victims, and others that are saying they want the full story. They want it all to come out about what exactly happened and where evidence might be and maybe a motive would come out. Do you think we will ever get all of that versus had there been a trial?
Yeah, so I'm glad you asked that question because it's something that I've seen being talked about on social media and other places. And one of the criticisms that I've seen of Bill agreeing to accept these guilty pleas is exactly that well, we want to find out what happened. But had this gone to trial, you would not have found that out. The public would not have found that out. There is no circumstance in which the defendant agrees to take the stand at his own trial and explain to the jury why he did something that he's trying to argue to them he didn't do at all. So you're not going to get it from him at the trial. You would just be relying on the evidence being presented by the state. And Bill Thompson has been very clear about what that evidence does and does not show. And as you heard, if you saw the press conference immediately after the sentencing, Bill, the lead investigators, they all confirmed we don't have evidence showing a motive. And so, had this gone to trial, there wouldn't somehow magically be new evidence that would suddenly explain why this happened. So, to the extent I understand that people have different feelings about the way that this case ended, but I don't think it's a fair criticism to say we would have learned more had this gone to trial. If anything, we would have learned less because you also wouldn't have the defendant saying in his own words that he did this, that he's guilty of it. So,
Mm, yeah. Uh, Having had this major case with international attention coming on the heels of the two Daybell cases last year and the year before, I mean, what has this been like for your office?
so we were involved in the Daybell cases actually pretty early on. It was a little bit before my time in that particular unit. But then the cases were given back, and you know this history better than I do, but the cases were given back to Lindsay Blake in Fremont County and to Rob Wood in Madison County. And our office then didn't get involved again until the Daybell trial. One of our deputy attorneys general from our office helped at that trial. Ingrid Beatty agreed to go and help them. And, that was chronologically, that came after we had agreed to assist Bill in this case. But it was yet another example of where I believe the Attorney General's office can play a role in cases, even where the county prosecuting attorney wants to hold on to it and be the lead attorney. I think Ingrid did a phenomenal job in that case at trial and helping them present evidence the way that they did. Obviously, that ended in a conviction and getting the death penalty. So the other way that I like to look at it in the role that I'm in is all of these cases, as we've kind of touched on, will eventually make their way to our office, whether we're assisting the county prosecutor or not. We're going to be handling the appeals. And then if it goes on to federal court and federal habeas, that's our office too. And so my view of it is not only are we able to step in and help out the county prosecuting attorney, but by doing that, we can ensure that the record that we are arguing later on the appeal is as good as it can possibly be with the assistance of our office.
Yeah. Jeff, thank you very much. Is there anything that you want to add?
I would just say, I think in this case, obviously a horrific case, the biggest case I think Idaho's ever seen, hopefully ever will see, at least of this nature. Uh, it was a real privilege to work with Bill Thompson. I'm glad that our office had the opportunity to do that. Bill is somewhat of a legend in prosecuting the prosecutor community here in Idaho. Before I got on the case, I didn't know Bill. I hadn't met him personally. All I really knew about him is I had heard that he was highly ethical and he had a reputation for being the only prosecutor in Idaho who had gotten a murder conviction without the body, which is a pretty big deal. And so I was very optimistic. I think that it worked out really well, and I was grateful for that opportunity. And then last, most importantly, I just wanted, since this is probably the only public time I'll speak about this case, my heart goes out to the victims in this case and the people who were affected. I think sitting through that sentencing hearing was an honor for me. It was a privilege to listen to the victims express how this terrible, terrible thing, how he had affected them. And it was great to see such a wide variety of emotion and responses, but in their individual way, every one of them was brave and powerful in expressing that. And it was just an honor to be there and a privilege to work on this case. And I do hope that this ending allows them to find some form of closure and that they can move on to the extent that's possible in a situation like this.